Hello, and thank you for taking the time to listen to this snapshot of Australian patent law. My name is Adrian Crooks. I'm a principal of Phillips Ormonde Fitzpatrick working in our legal group. I'm both a lawyer and a patent attorney, and a significant part of my practice relates to patent disputes. And today I will be discussing validity challenges under Australian patent law. There are a number of different mechanisms by which a third party can seek to challenge the validity of an Australian patent or patent application. And the process and venue for making such a challenge will typically depend on the current status of the patent, but there may be circumstances in which a party has a choice as to which mechanism they wish to use. The level of involvement that they wish to have in a challenge might be a relevant consideration as to the mechanism, as well as the basis for the validity challenge, which in fact may dictate the mechanism that can be used because some grounds are only available in certain circumstances. The first mechanism that I want to discuss is referred to as a Section 27 notice. And this is the mechanism under the Australian patent system that allows for the filing of third-party observations in relation to pending applications. Once an Australian patent application becomes open to public inspection, a third party can file a Section 27 notice, and this gives that party an opportunity to make observations asserting that the invention, which is the subject of the application, is not a patentable invention, on two grounds. Firstly, a lack of novelty, or secondly, a lack of inventive step. There are no other grounds that can be raised as part of a Section 27 notice. The notice allows a person to identify documents that they rely upon to assert the lack of novelty or inventive step, and also provide observations as to why the application is invalid in light of those documents. The notice can include both technical information and also legal argument. And Section 27 notices can be particularly useful in bringing non-patent literature to the attention of an examiner. Such prior art may not readily be available to the examiner and can be brought to light usefully by this mechanism. Where non-patent literature is relied upon, it's also important that the notice include evidence as to the date of publication or use of that information. Under the Australian patent regulations, any information set out in a Section 27 notice must be considered by the examiner during examination. However, it's up to the examiner to determine what use of that information they will make, and they may decide not to raise an objection based on information in the notice, and the person who files the notice has no further involvement in the examination process once it's been filed. The filing of the notice doesn't entitle a person to make further observations in relation to any argument or amendment that is made by the patent applicant, although it's important to note there's no limit to how many notices can be filed. So if a particular issue is raised and is not relied upon by the examiner, it is possible to file further notices. The Australian patent system also includes a mechanism for pre-grant opposition. Once an Australian patent application has been examined and accepted for grant, a third party has 3 months from publication of acceptance to commence an opposition proceeding. An opposition is commenced by filing of a simple notice which identifies the opposed application and the name of the opponent. After the initial opposition notice has been filed, the opponent then has a period of 3 months in which to file a statement of grounds and particulars, and that statement is intended to give the patent applicant notice of the case that the opponent is going to bring. The statement of grounds and particulars identifies, first of all, the grounds on which the opposition is based, and then also the particulars or material facts on which each ground is based. So the notice would identify a ground of novelty and would then particularise the prior art documents which support that ground. The notice, however, does not need to include evidence by which those facts are intended to be proved. In an opposition, in addition to the grounds of novelty and inventive step, it is also possible to raise grounds of entitlement, lack of subject matter, utility, and issues relating to the adequacy of the specification. After the filing of the statement of grounds and particulars, the opponent then has a further period of 3 months in which to file evidence in support of its challenge. That evidence will typically be provided by way of a statutory declaration from witnesses who can give evidence in relation to factual matters which might be relevant to the grounds of opposition, but also expert witness evidence. Preferably, expert witness evidence will be provided by an independent witness having expertise in the relevant field, ideally in Australia. However, evidence from non-Australian witnesses and witnesses who are associated with either of the parties is also admissible. Once the opponent has completed the filing of their evidence, the applicant then has a period of 3 months in which to file any material in answer, and the opponent will then have a further opportunity to file evidence in reply. At the completion of the evidence stage, an opposition is ready to be heard, and a hearing may be conducted based on written submissions alone, but will more commonly involve an in-person hearing before a delegate of the Commissioner of Patents. When an in-person hearing takes place, the parties will also file written submissions in support of their position. Typically speaking, the Patent Office seeks to issue a decision on the opposition within 3 months of the hearing. The patent applicant is free to make amendments to its application at any time during the opposition, so it may do so in response to matters raised in the statement of grounds and particulars, or once it has seen the evidence filed by the opponent. If a ground of opposition is upheld, the applicant will also be given an opportunity to propose amendments in order to overcome any objection that arises from that successful ground. There is also an opportunity for either party to an opposition to appeal the Patent Office decision to the Federal Court. And while this is described as an appeal, it is in fact a de novo hearing by the court, which will consider new evidence if filed and will make its own determination as to the opposition grounds that have been raised. The next mechanism is re-examination, which can occur once a patent has been granted. After grant, any person, including the patentee, may file a request for re-examination, and if a third party files a request, the Patent Office must re-examine the patent and report on whether the patent fails to comply with any validity requirement that's been raised. Like a Section 27 notice, a re-examination request allows third-party observations asserting that the invention, the subject of the application, is not a patentable invention on the basis of lack of novelty and inventive step, but also allows grounds of subject matter, utility, and the adequacy of the specification to be raised. Again, the request should identify documents relied upon, provide observations as to why the application is said to be invalid, and can also include legal argument. If the Patent Office, upon conducting re-examination, reports adversely in light of any of the material that has been raised, the patentee may file a statement in response to that, or may seek to amend the patent to address any validity issues that have been identified. As with a Section 27 notice, a person who files a re-examination request has no further involvement in the re-examination process. They're not entitled to make further observations in relation to any argument or amendment which is made by the patentee. The fourth mechanism that is available to a third party under Australian patent law is revocation of a patent after grant. So once granted, any person may apply to the Federal Court seeking revocation of the patent. An application for revocation can be made at any time after grant, and can be made in the absence of a claim of infringement. There is no requirement that a person making a claim for revocation show standing in order to bring that claim. A claim for revocation can be made on any ground on which a patent could have been opposed, and there are also some additional grounds that are only available as part of a revocation proceeding, being that an amendment, the patent itself, or an amendment to the patent was obtained by fraud, false suggestion, or misrepresentation. As with an opposition proceeding, a revocation action will involve the filing of evidence by the revoking party and the patentee. And depending on the grounds of invalidity which are relied upon, the revoking party may be able to seek discovery of documents from the patentee that are relevant to those grounds. A revocation proceeding will also be determined by a hearing before a judge of the court, and will typically involve oral argument and cross-examination of witnesses. An important difference between a revocation proceeding before the court and an action before the Patent Office is that in revocation proceedings, a patentee requires an order from the court in order to make an amendment to the patent. Unlike the Patent Office, the court has discretion to refuse an amendment, even if it meets the formal requirements of allowability. A patentee seeking to have the court exercise its discretion in its favour to make an amendment will typically need to disclose all of the relevant circumstances surrounding the application to amend, and that includes material which might ordinarily be the subject of attorney-client privilege. And a failure to disclose that information could result in the court refusing to make the amendment. After a decision in a revocation proceeding, either party has the right to appeal to the full federal court. Unlike an appeal in an opposition proceeding, however, such an appeal is not a rehearing. An appellant will typically need to show an error of law in order to succeed on that appeal. The matters that I've discussed to date relate to standard patents and patent applications in Australia. The Australian patent system also includes a second-tier patent known as the innovation patent. And while these are being phased out, granted innovation patents will remain part of the Australian patent landscape for some time. The mechanisms which are available for challenging the validity of innovation patents are broadly the same as for standard patents, but there are some key differences. To some extent, these arise because innovation patents are granted without substantive examination. It's possible for a third party to request examination of an innovation patent, and they can also file a Section 28 notice making third-party observations, asserting that the invention is not a patentable invention, again limited to the grounds of novelty or innovative step. At any time after an innovation patent has been examined and certified, it can be opposed by a third party. An opposition to an innovation patent is commenced by filing, first of all, a notice of opposition, but together with a statement of grounds and particulars and the evidence in support of the opposition. So all three components must be filed at the same time. Once the opposition is commenced, the patentee then has a period of 3 months to file its evidence in answer, and there is again an opportunity for the opponent to file evidence in reply. Once the evidence stages have been completed, the opposition will then be heard in the same manner as for a standard patent. As well as opposition, after certification, a third party may also request re-examination of an innovation patent by the Patent Office, or may apply to the Federal Court seeking revocation of the innovation patent. The re-examination and revocation proceedings for an innovation patent are broadly the same as for a standard patent. So, as discussed, the Australian patent system includes a range of different mechanisms for challenging the validity of patent rights, and each of those mechanisms has its own advantages and disadvantages. Section 27 notices and re-examination are typically faster and less costly options, but that comes at the expense of a lack of involvement in the process. Opposition and revocation proceedings allow the pursuit of a wide range of invalidity grounds, and they also allow active participation by a challenger, but they can take a greater time to resolve and will often involve greater resources to pursue. The right mechanism for a third-party challenge therefore requires careful consideration of both the legal basis for the challenge as well as the broader commercial context for making such a challenge. If you're interested in challenging an Australian patent or patent application, or would like any further information about the matters discussed today, please feel free to contact me or any of our patent attorneys here at Phillips Ormonde Fitzpatrick. Thank you again for taking the time to listen today,